Last week I had posted a message in our group that limitation under section 107 subsection 4 of CGST Act can be condoned beyond a period of 3 months plus 1 month. It may sound very strange to most of you, as most of the high courts, including Supreme Court, have confirmed that delay under these circumstances is not condonable, including in writ petitions few high courts have held now. But I have come across a judgment, though under a different enactment, under Land Acquisition Act, in the case of Deputy Commissioners and Special Land Acquisition Officer versus SV Global Mill Limited. This particular judgment was delivered based on civil appeals and SLPs in hundreds of cases. They were batch matters. They were considered by a DB of Supreme Court, by the bench headed by Justice M.M. Sandresh. Now, the question before High Court was that under particular provision, that is section 74 of this Act, there was a limitation period of 3 months, and this delay could be condoned by maximum 3 months more. We have a paramateria provision of 3 months and 1 month in section 107. Now, the analogy is here that the Attorney General put in a very strong resistance and quoted more than 27 judgments of High Court and Supreme Court, where under the particular circumstances of a particular enactment, the courts held that under similar provisions, delay is not condonable. Now, after writing many pages, and it is from 131st paragraph onward, Supreme Court analyzed the law. Supreme Court said Limitation Act 1963, section 29(2), subsection 2. The Supreme Court, after reviewing the main judgment of this issue in Mukri Gopalan's case, went on to hold that the language used in 29(2) of Limitation Act is that the provisions of section 4 to section 24 of Limitation Act shall be applicable to special statutes insofar as to the extent these provisions have not been specifically and expressly excluded from a particular provision of the special statute. In other words, when I read section 107, there is no specific and express exclusion of section 4 to 24 for the purpose of filing an appeal. Now, if that be so, the judgments earlier delivered by High Court, various High Courts and Supreme Court cannot be held to be valid, because such points were not raised. Though in one of the Calcutta High Court judgments, they had raised this point and they had said delay could be condoned. But Supreme Court stayed the matter. The matter is still pending. Now, this judgment came on 9th February 2026. I'm sure most of you may not have seen these judgments so far. In any case, our bar associations, these kind of judgments are not circulated, nor they bother to read about it. Now, in all such batch matters running into hundreds of cases, the DB invoked section 29(2) and they differentiated between express exclusion and implied exclusion. They said the earlier judgments of High Court and Supreme Court were based on implied exclusion, based on language used in the statute, whether the language was very imperative, whether the language really clearly gave an expression that the provisions of Limitation Act have been expressly excluded under section 29(2) of Limitation Act. Now, here Supreme Court laid down the onus on revenue to prove that there is an implied exclusion. It is not for the taxpayer or the appellant to prove that there was not an express exclusion. It is for the revenue. So the onus was shifted to revenue in this judgment, and they say, okay, now this onus has to be discharged by revenue. So if they want to rely on any other judgment, they have to show whether the judgment was passed under a paramateria act. Supreme Court also laid down a principle of law here, all the judgments were laid down under different contextual framework of a particular enactment. And we will have to also examine the enactment whether if right is to be curtailed, can there be implied exclusion as revenue may contest tomorrow. Therefore, in this judgment of SV Global, the Supreme Court said, notwithstanding the 3 months and 3 months or 3 months and 1 month period under CGST Act, the delay could be condoned because these provisions have not expressly excluded the applicability of Section 29(2), that is Section 4 to Section 25(4), Section 4 to 24, that includes Section 5, where delay is condoned. Therefore, in my post few days ago in our group, DGST group, I had mentioned a delay couldn't be condoned, and I also gave an opinion to our company, and that appeal is already filed with condonation of delay. Let them dismiss. Now, the message of this judgment is clear. Wherever appeals have become time barred, under Limitation Act, the period is 3 years. Wherever appeals have become time barred, and even if the tax has been deposited, try to file appeal now with condonation of delay. Now, the reasons for condonation of delay could be whatever you had earlier, and now you had the judgment came right now. So therefore, I'm not saying this ignorance of law, but this could be made a possible ground to get the delay condoned. Talk to your clients and let the matter not go unheard on merits. Therefore, friends, this is the latest from DGST Group, judgment of SB Global Limited, stating therein that delay under CGST Act beyond 4 months can be condoned. And this judgment has reviewed all the judgments of Supreme Court and High Courts. In total, around 73 judgments have been reviewed. And the DB came to this conclusion. Now, most of my friends might say that this judgment is of a DB. Earlier judgments were for 3 judges or 5 judges. In my view, it will make no difference because this bench has interpreted law. They have not said those judgments were wrong or right or valid or invalid or they were overruled. They distinguished those judgments based on interpretation of law as they hold it to be. Enjoy this video. Thank you.